We are going to clarify some of the legal conditions where the doctor has been confronted over the time. Let us start with the medical reports and certificates. A medical report is a systemic documentation of the patient's individual medical history and care. All the patient should have their records, and it should be kept privately, and it should be kept for certain time. All these records is confidential. It shouldn't be given to a third party without a previous approval of the patient or a written consent from the patient. If you do so, you will breaching the confidentiality, which has an ethical and legal consequence. The legal consequence if harm happened to that patient due to release or breaching of his or her confidentiality, there will be imprisonment for 6 months and a fine. And here's another article 310. If you are a doctor, surgeon, pharmacist, midwives, and so on, and if you have um, breaching the confidentiality of the patient, okay, except in certain condition where the law allowing you, this will be imprisonment from from about 6 months, and there is a fine not exceeding 500. As long as you are practicing, you may be asked for certificate, medical certificate of course, notification, reports, or other documentation signed by you and given to workplaces or to the court and so on. So, what is the importance of the medical records? It is served as a plan for patient care. You are writing what you find and then how you are interpreting this and how you giving your patient the treatment and if there is improvement or not and so on. So it's a plan for patient care. Secondly, it can give you and other healthcare provider a continuity of care to that patient. It is a sort of communication between you and other colleagues. If you are asking for consultation of certain other these records can protect the legal interest of both patient and the doctors. Whenever there is a malpractice claim, the doctor can defend himself by using this documentation. At the same time, if there is a mistake done by the doctor, the patient can prove his rights through using this documentation. At the same time, it can be used as a source of education to the medical student or residents. They can provide data for auditing and quality assurance in hospitals, and they can provide data for medical research. Any physician who use or receive the information from the medical records share the responsibility of the confidentiality toward the patient's data. The physician have a responsibility to be aware about the guidelines in the hospitals and about the laws of the country, whatever is this laws. If you are giving your patient a report which is not accurate, this means you are trying to um, give him a favor about a data which is not true. At that time, you will be accused by forgery and there will be imprisonments and you will pay a fine. This is the articles of civilian laws and criminal laws uh, in Egypt. The first one, 221, said that if you are doing or writing a certificate or a report, medical report, and it is not true, about the presence of certain infirmity or disease for certain person to get away from certain military service, you will be imprisoned. Article 222, if you are giving a certificate or a report which is considered as a compliment to your relative or persons, and you know that you will be imprisoned and you'll be a fine about £500. If you are taking money for this, you will be considered as committing a crime of forgery, and it will be harsh imprisonment in this condition. There is certain circumstances in which the physician is asked to issue a medical report, like when he is attending a birth. You should write a birth certificate with all the data about the mother name, the sex, the time and place of the delivery of that baby. You can write a death certificate if you are charged to do that, and if you find something like violent death, you shouldn't do it. You shouldn't write that certificate. In case of vaccination, you should write a certificate that this person has been vaccinated, and you write uh, the name of the vaccine and the duration and the amount and so on. And the place. If you find a person had contagious disease, you should mention this, or you should inform the authority, like the public health section or the Ministry of Health. If you find a work accident, you should report this about the infirmity, that a time of absenteeism, and so on. In case of injury, you should inform the police about the personal data and the wounds and the causative agents and so on. In case of occupational disease, you should report it. Okay. Sometimes you may be asked for age determination or age identification of certain person, like for a criminal purpose, because by law, if you are less than 18 years, you are a child, and you will have different laws to be governed your condition, and you shouldn't be in prison and so on. So it is critically to determine the age in this condition. Another certificates like testing the sanity of a patient, like giving sick leaves report to students in certain condition in insurance, medical insurance. You can write, or you will be asked for that. Here a problem: a patient entered the emergency department unconscious and suffering from scratches, bruising all over his body, especially the neck. After 5 minutes, the patient is found to be dead. His relative asked for a death certificate from the physician to bury him. Do you give them this certificate and you find this scratch mark? If you are refusing, why you are refusing? Okay. Of course, you should refuse, and you have the right to refuse because you are suspecting there is a criminal act, and it may be a suicide. So, what is the legal rules that should be followed in issuing a medical report or certificate? It should be given to the patient himself, except if he is incompetent or a minor. This means his age is below 18 years. If he is insane, okay, in this condition you can give him this certificate to his guardian, or if he asking you or giving you permission to give this certificate to another person. All the certificate data should be accurate, honest, includes all correct and complete information about his condition as he asked. It shouldn't entail any personal expectation. Okay? It should include the details and of the data that he has asked for, the patient asked for. It shouldn't include any dictated data by any person. Don't let the patient call you or giving you a written paper said that you should write this in the certificate. Okay? Except if it is all true and all is correct. The physician should be sure of the identity of the person who is giving him the report. He shouldn't sign the certificate if he is not the one who wrote it. If someone of your colleagues write this, don't sign for him. Here it is another problem about a worker in a factory is injured in his hand while working, which necessitates amputation of his index finger. He asked the occupational physician to write a report on his case, and the next day he was so tired and asked a friend to receive the report for him. What do you think the report should include, and do you consider the physician behavior is right or not, and why? Occupational disease report should include date, place, type of disease, okay, the need for diminishing effort or absenteeism, okay, if he is in need for change in his work after the accident, and the time needed for complete healing. It should be given to the patient except in certain conditions, as we said before. How about retention of the medical records? How long do you preserve these records? According to the medical consideration, which is a primary basis for deciding how long to retain the medical records. For example, operative notes and chemotherapy records should be always a part of the patient chart. If a particular record is no longer needed to be kept for certain medical reasons, the physician should check the laws and see if there is a requirement that this record should be kept for a minimum length of time. Usually, we keep the record from 3 to 5 minimum, and in certain conditions, if there is a case or if there is accusation, it should be kept until all the case time is finished. Immunization records should be kept always if the patient is minor, and the limit needed to keep his records, not because he may claim for malpractice, it should be kept until the age of 18 years, where he can change his mind or take a decision for himself. Just to revise by question, the legal rules in issuing a medical certificate should include all the following except, of course, it is personal expectation. Reporting in cases of injuries include all of the following except penalty. A physician must report all cases of contagious disease. Is it true or false? It is true. This is Article 298 in the civil law. It is talking about the imprisonment and the fine that you should pay if you are giving a false certificate or report. The malpractice, of course, it is one of the elements where there is legal consequences if you are doing something wrong, and it is given in a separate lecture. What do we mean by a consent? It is the patient's approval or agreement on permission to receive medical treatment or therapeutic treatment or joining a research. I will talk sometimes in Arabic and I will repeat it in English to clarify some items. يبقى بالمنظر ده احنا بنتكلم على الموافقة المستنيرة أو الموافقة المبنية على علم، إن المريض بيوافق على أي تدخل طبي، خلاص، سواء للتشخيص أو للعلاج أو عشان يدخل ريسيرش، خلاص، والموافقة دي بتبقى لها كرايتيريا وشروط. Let us start by the types of the consent. The consent may be implied, which means you haven't to ask the patient to give you a consent in certain conditions, like when he is coming to your clinic. This means he is approved on initial examination. If he is coming to your lab, this means he is approving for sampling. Okay, but just the general examination, just vaccination, so he is coming to certain act, and you couldn't or you shouldn't ask everyone, do you approved for general examination whenever he is joining your clinics. يبقى كلمة implied consent معناها ان هو مجرد دخول المريض عليك في العيادة هو كده موافق ان انت تكشف عليه الجنرال العادي، ما تفتحلوش خراج، ما تطلبش حاجة مثلا هعمل له لا بون مارو اكزامينيشن، لا مثلا بون مارو سامبلينج او حاجة، لا، لكن هو الجنرال اكزامينيشن. لو هو انت في مكان فيه تطعيمات وهو دخل عليك يبقى هو موافق ان هو ياخد الفاكسينيشن، مش هتقول له اديكي فاكسينيشن ولا لا. لو هو انت داخل عندك معمل وهو دخل عليك، ده معناها ان هو موافق ان انت تاخد منه سامبلز. The other types is the informed consent, which is agreement obtained from the person, either a patient or a volunteer, which whenever they are joining the research, or from an authorized representative, from a parents, for example, for their children. It is providing information by you as a physician to the patient to let him take a decision about the therapeutic interference or diagnostic interference or for research purpose. يبقى هي من اسمها informed consent، بتدي information to take the consent on this information. Third type is called anonymous consent, which is usually in psychological groups. Okay, whenever you are joining, it is a sort of anonymous, it is not specific. Do we have to take a consent? Yes, we have to take a consent because it is part from healthcare consent articles. Okay, and this is carried out for either therapeutic, as we said before, preventive medicine, palliative care, diagnostic care, cosmetics, any health related purpose. Okay, and of course the research. So who can give you this consent? Can I take this consent from a mentally affected person, from unconscious person, from a child, from a teenage? No, we cannot take a consent from these persons. So I will take a consent from a sane, conscious, above 18 years person, from himself. Okay, you are taking an appointment with that patient and you are giving him the data or the details, and then you are taking his consent. Whenever there is some preventive conditions like being below 18 years or affection of sanity, okay, in this condition you will take this approval or this consent from the legal authority or what we call a legal guardian، من الوصي. لو حد سنه صغير او حد ملكاته العقلية متأثرة بناخد الحكاية دي من الوصي. Sometimes you are taking a patient's spouse consent in certain conditions if it is the operation or the intervention will affect the life of both. And we are taking sometimes a patient's nearest relative over the 18 years whenever this 18 years old is unconscious or uh, not safe. We can take the consent all the time except in cases of emergency. When there is a condition, a life-saving measurements for the patient, no one with the patient, okay, you have to interfere and you are taking a second opinion from one of your seniors, okay, and this will be documented on the medical record that it is the best for the patient life-saving measurements, and this is not occurring in each country. In most of the countries, they are approving for waiving the consent in emergency condition, but not all in all countries. So before going on and taking the risk for doing something for someone to save his life, be sure that the country laws approving your interference. So, to take this consent, you must meet the patient, you must know the patient through the regular doctor-patient relationship. Okay, you are taking this form after you are explaining the data to the patient. Whenever you are planning to take a procedures, you are planning to take certain interventional procedure, you are talking to the patient and give him time to think and respond to your consent form approval. And for the consent to be valid, it should be voluntary. You understand the meaning of voluntary. You are don't force the patient. You are not deceiving your patients. Okay, you are just explaining what is going on, what is the risk if he doesn't do these procedures, and then he should sign this voluntary تطوعي يعني. This condition will affect the validity of the consent. If you are forcing your patient, if you are terrifying him, if you don't sign this, just like now, I will throw out of my hospital. No force, no fear, okay? And it should be after sufficient information. So to be clear and to obtain a valid consent, it must be given the person with legal capacity, sane, conscious over 18, and he have a proper intellectual capacity to understand what is going on about that procedures. This consent form should be written in a language that the patient can understand. It should be given freely and voluntarily. It should cover the procedures that you are carried on. He must be understanding what is going on in this procedure in a simple way, of course, and what is the risk and what is the benefit from these procedures. At the same time, you must offer an alternative treatment if it is present. If there is a choice between several methods of treatment, for example, if I have an enlargement of my thyroid, I can treat it conservatively by tablets or by surgery or by whatever. Okay, you should offer the patient the two way or the two methods. The person must have time, okay, and explanation for that procedures. Give him the opportunity to think, and there must be a witness for whatever you are going to approve. should document your consent. لازم يبقى في ورق مكتوب بالconsent form دي، مش مجرد كلام مع المريض. When the proper documentation, you are preparing this document of consent with all the items that have been given, and it will repeat it again for you. It should be dated, signed by the patient or the guardian. A witness, it's preferred to be one of his relatives. Don't involve the nurse in this process, because sometimes they can be alleged that you are deceiving me and the nurse joining your deceiving process. This document of informed consent should be prepared in a duplicate, and a copy will be given to the patient. The other copy will be kept in the medical record. So, whenever you are going to make an informed consent for treatment or procedures, what you should write? Okay, you should write the name of the patient, the name of the disease, okay, your diagnosis I mean, okay, then you will mention the nature of the decision or procedures that will be carried on, the alternative, the risk, all the types of the risk known, the benefits, okay. Uh, there should be a statement at the end of the paper that I read this, or I read this and I understand every word before signature, before the patients are going to sign it, okay, because it is one of the lawful criteria. And it should be another statement that I accept this intervention or this procedure. It is one of the legal points also. What about the standard consent form in surgery? Besides the patient identification data like the name, the number, the age, and address, then you are going to mention the diagnosis and the procedures that will be performed, the types of anesthesia, its complication, the name of the medical practitioner that will perform the procedures and the anesthesia. And you should write a permission for extending or extended surgery if you are expecting that you may find some complication or some extension of the surgery. For example, you find a mass or a tumor or something, and you may need to extend your surgery. If you are expecting this, please write it and don't perform it without the approval of the patient or his next of kin or his family. There should be a statement that the person who are performing the procedures has explained the nature of the procedure to the patient with the risk, and he is approving. Another statement, or this for the law, another statement to indicate that the patients had received and read it carefully all the explanatory notes, and he is approving. Then there will be a signature from the patient or next of kin, and the signature of the practitioner and the signature of the witness. This should be prepared in two forms, and one will be with the patient and another form will be in the medical. Okay, after all that, if you are doing all this and the patient suddenly say, no, I don't want to perform your procedures, and he insists, and you are trying to convince him without any good reasons. At that time, you should take what we call a refusal of treatment, that you are advising your patient about the risk if he is not doing these procedures, and he understands this, and his mental capacity is very good, and he insists to make an act against your advice. He should sign this for you. Whenever you are waiving or you are not taking the consent of the patient, you will be exposed to, if you are in Egypt, this will considered as a harassment, and will be imprisonment from 3 to 7 years. And if the patient is under the age of 16, this can be given to the maximum of imprisonment, maybe 15 years. If you are talking about abortion, if it is illegal abortion, okay, if you harm the patient or giving her medication, okay, you will be imprisoned. If she knows that, okay, and she taking the medication to induce abortion, she will be imprisoned to the patients. And for the doctors, this can be for maybe 15 years in prison.